Nobody in our constitutional order has a scintilla of executive authority unless it has been delegated to that person by the president. They're all suing to get their positions back, their positions of authority, their positions of delegated executive authority to compel the president to have a court, an Article 3, unelected, black-robed, tyrannical, inferior district trial court order the Article 2 executive branch president to delegate his authority against his will. The great and powerful President Donald J. Trump has ordered the firing of Rebecca Slaughter from the Federal Trade Commission, and of course, she has sued in federal court to get her job back, received an injunction against her firing from an unelected black-robed, tyrannical, inferior federal district trial court judge, and this dispute over Trump's power to fire the heads of so-called independent agencies. As we all know, SCOTUS has so far tossed out every injunction and every similar firing case involving Trump's exercise of his core and plenary Article 2 executive branch powers, and we have every reason to expect SCOTUS will do that again here. The issue in these cases has always been, does the elected Article 2 executive branch president, to whom the U.S. Constitution grants 100% of the executive authority of the United States, does he have the constitutional authority to choose whom he delegates his executive authority to? Nobody in our constitutional order has a scintilla of executive authority unless it has been delegated to that person by the president. And the fundamental question we're dealing with here is, can the president be compelled to delegate his executive authority against his will? That's really what all these cases involve. Now, it's somewhat complicated because our federal government has idiotically decided to create something it calls independent agencies, and then Congress assigns termination protections for the heads of those independent agencies. They can only be fired for misconduct, for failure to do their jobs, variety of other termination protections. It varies from job to job. And then they say, well, Trump, any president, can't fire these people unless those conditions have been met. The trouble is, by doing that, you're effectively saying that Congress can compel the president to delegate his executive authority against his will, and Congress is not granted that power in the Constitution. It's a separate branch of government. It's the Article 1 legislative branch of government. The president's the Article 2 executive branch. And then the courts will step in and say, well, we have the authority as Article 3 judicial branch, inferior court judges, to order the president to delegate his executive authority against his will. That's nowhere to be found in the Constitution. And the notion of independent agencies, there is no Article 4 branch of government called independent agencies. These so-called independent agencies have no legitimate existence within our constitutional order. You cannot be a facet of government unless you fall within one of the 3 branches of government. And these agencies are not legislative. They're not just creating laws to be executed by others. They're not judicial. They're not settling cases and controversies, or at least that's not their only or even core function. They often have rulemaking capability. They often have pseudo-judicial-like capability, but fundamentally they are executing, carrying out laws and policies. They are members of the executive branch of government, but they wish to be immune from the constitutionally delegated executive authority that exists only within the President of the United States. All right, in the Supreme Court of the United States, whether the statutory removal protections for members of the Federal Trade Commission violate the separation of powers. In other words, does Congress even have the authority to constrain the president's ability to fire executive authorities? And if so, whether Humphrey's executor should be overruled? That's the first question. And 2, whether a federal court may prevent a person's removal from public office either through relief at equity or at law. Relief at equity means giving them their job back. Relief at law would be monetary damages, back pay, the kind of stuff that Humphrey's estate got and Weiner got. Amicus Curiae, friend of the court, America First Legal Foundation is a nonprofit organization dedicated to promoting the rule of law in the United States, defending individual rights and the separation of powers, has a substantial interest in this case because the ruling in Humphrey's executor subverts the president's authority to execute the laws. Obviously, the president cannot be held accountable for faithfully executing the laws as the Constitution requires, if he cannot choose to whom he's delegating his executive authority. If people like the Hampton Dellinger of the Country Club Dellinger is being insubordinate and issuing orders contrary to those of the president, you can't have that. AFL also writes, these rules are also incompatible with the presidential removal prerogatives established by the court in Myers and reaffirmed in Free Enterprise Fund and Seal of Law and Collins v. Yellen. It's long past due to overrule that derelict decision, Humphreys, and everything that comes from it. Summary of argument. The ruling in Humphrey's executor has been on a collision course with Myers since the day it was decided. Myers holds that Article 2 gives the president a categorical prerogative to remove executive officers of the United States that are appointed by the president with the Senate's advice and consent. And Myers forbids Congress to limit the president's removal power over these executive officers in any way. All right, so this is a good point to bring up. What they're really talking about here are what are called principal officers of the United States. There are many people in the executive branch who do get employment protections through the civil service program. And there's administrative procedures that need to be followed if the government wants to fire someone from a civil service job. Those are a different category of job than principal officers, because those lesser jobs that have employment protections are not making authoritative decisions about the execution of the laws. They're just doing whatever. They're a secretary. They're a mid-level manager. They're not executing broadly policy decisions of the U.S. Those people have civil service protections. The principal officers of the U.S. are like, the generals and the colonels of the executive branch. Those are the ones that are nominated by the president and then require the advice and consent, confirmation by the Senate. They are exercising discrete executive authority, and therefore, by my reasoning, our reasoning, AFL's reasoning, they must be delegated personally executive authority by the president, and that cannot be done against the president's will. But this Supreme Court abruptly changed course in Humphrey's executor, holding that the president lacks constitutional authority to remove members of the Federal Trade Commission in the teeth of a congressional statute protecting them from at-will removal. The Supreme Court reached this conclusion for two reasons. First, the court held that FTC commissioners do not wield executive power and therefore do not qualify as executive officers, what I've just called principal officers, subject to at-will presidential removal. Second, the Supreme Court ruled that Myers extends no further than the particular facts of that case, and anything in Myers that purports to confer an at-will presidential removal prerogative over any officer other than postmasters is dicta and non-precedential. The narrow point actually decided in Myers was only that the president had power to remove a postmaster without the advice and consent of the Senate as required by an act of Congress. In the course of the opinion of the court, expressions occur which tend to sustain the government's contention, but these are beyond the point involved and therefore do not come within the rule of stare decisis. They don't have precedential authority. So dicta is of course, a Latin word, but it's a legal term of art meaning portions of a court decision that are not core to the central holding of the court's decision. So there'll be a key issue in any court decision. For example, in this case, we have these two questions, right? We started off. What are the two questions the Supreme Court wants answered here? Well, the Supreme Court, when it finally publishes a decision, its decision might be, who knows, 30, 40, 60, 80 pages long. I imagine that Justice Ketanji, I'm not a biologist, how would I know what a woman is, Jackson, will write an 80-page dissent. And there's lots of stuff that can be said in the decision that is not directly relevant to these two specific questions. And that stuff that's not relevant to answering the two specific questions is referred to as dicta, as passing remarks. And passing remarks not central to the decision of the case do not have precedential authority. They're not binding on other courts, and therefore they also don't get the respect of stare decisis. Stare decisis says that an existing Supreme Court, for example, should respect the rulings of previous Supreme Courts. That once a legal rule is established by the Supreme Court, it should be sustained as a matter of policy unless there's a really good reason not to do that. So where there's dicta that doesn't have precedential authority, that doesn't have the respect of stare decisis. A lot of times what you'll see leftist judges do, by the way, is these unelected, black-robed, tyrannical, inferior district trial court judges, they'll do this all the time. They'll go through an 80-page decision and find a phrase and take it completely out of context. It's dicta. It doesn't have any presidential authority. And then they'll present it as if it was a legal authority. It's just a form of lying within the legal domain. All right, Humphrey's executors claim that FTC commissioners lack executive power was indefensible even in 1935. It's even more indefensible today because Congress has given the FTC additional executive powers it did not possess at the time of Humphrey's executor. Worse still, Humphrey's executor declared that quasi-legislative powers, whatever that means, there's no quasi-legislative fourth branch of government in the Constitution, folks. Worse still, Humphrey's executor declared that quasi-legislative powers, whatever that means, could be exercised by administrative agencies rather than by Congress, and that quasi-judicial powers, another undefined term, like what the F does that mean, could be vested in agencies rather than in Article III courts. The Constitution, however, makes no provision for quasi-legislative or quasi-judicial powers, and it makes no allowance for independent agencies to wield those powers at the expense of Congress or the federal judiciary. The Supreme Court decision of Humphrey's executor also described the FTC as an agency of the legislative or judicial departments of the government. But the ruling of this court do not permit the legislative department to participate in the administration of the laws, execution of the laws that it enacts. That's why we have separate branches of government, even if this is done through the agent of the legislature. Nor does the Constitution permit non-Article III entities, judicial branch entities, to act as agents of the judicial department. The judicial power of the United States, all of it, must be vested in Article III tribunals and not in administrative agencies. The founders created these three distinct, separated powers of the Constitution, Article I legislative, Article II executive, Article III judicial, for good reasons, to prevent tyranny. They separated these powers because many governments have these powers combined. Many governments have these powers combined. They combine the legislative and the executive, or the legislative and the judicial. And what happens is it foments the concentration of power in tyrannical ways. So our founders created the three branches of government, Article I legislative, Article II executive, Article III judicial, so each would be jealous of its own power and prerogatives and prevent the concentration of power into tyranny. Remember, our founders, when they ratified the Constitution, had just fought a desperate 8-year war against the most powerful military on the face of the earth, specifically to free themselves from tyranny. It was a top priority for them in forming a new government that government be resistant systematically and intrinsically to the resurgence and return of tyranny, which they saw as an evil that simply follows from human nature, and unless you build the system to inhibit it, it would surely come back. Back to the brief. The Supreme Court opinion in Humphrey's executor is a debacle. It defies the earlier holding of Myers. It blinks reality by claiming that the FTC wields no executive power, and it establishes ill-defined and constitutionally dubious categories of quasi-legislative and quasi-judicial powers that Congress may purportedly confer on so-called independent and politically unaccountable agencies. This Supreme Court should overrule Humphrey's executor for each of these reasons. Now, we just talked about stare decisis, that the court is obliged to give respect to prior decisions unless there's a good reason. And they're going to talk about that now. Stare decisis, as the Supreme Court has observed many times, is not an inexorable command. So in Dobbs, this is the abortion overturning Roe v. Wade decision. Obviously, they didn't give Roe v. Wade the respect to stare decisis. They overturned it. This court does and should overrule precedents that are poorly reasoned, that are incompatible with other rulings of this court, or that produce doctrines that are unclear or incapable of principled application. Humphrey's executor fits each of these descriptions, making it a suitable candidate for repudiation, despite the presumption of correctness that this Supreme Court typically gives its prior decisions. Humphrey's executor is incompatible with the holding of Myers, the earlier case, and it rests on a transparently false assertion that the Federal Trade Commission lacks executive power. Myers, the decision before Humphrey's, its holding is clear and unequivocal. Article 2 prohibits Congress from limiting the president's removal power over executive officers who were appointed by the president with the Senate's advice and consent. It's worth keeping in mind that a lot of this stuff was happening during the New Deal era, after the Great Depression. FDR, he was trying to create this mythical fourth branch of government, so he could create the administrative state, the bureaucratic state, where all the thought leaders and experts would rule over America like micro kings in masse. And so the Supreme Court was holding him back. So Myers was a way of saying, no. Whatever executive branches you create, they are subject to the authority of the next president too. And so he tried to prevent that by making them so-called independent agencies. He threatened the Supreme Court with packing the Supreme Court. If you don't do as I wish, if you don't help me create this unconstitutional administrative state, these so-called independent agencies, I'll simply pack the Supreme Court. I'll get Congress, which he also had effective control over, to appoint another dozen Supreme Court justices, and they'll all be my picks, and then they'll rule my way. Of course, that's a formula for national demise, because then the next time the opposition party is controlled, what do? Well, they just appoint another 20 Supreme Court justices, and the next cycle, another 40 from the other side, and pretty soon you have a parallel legislator in a Supreme Court numbering in the hundreds. The brief continues, Humphrey's executor is incompatible with Myers because it allows Congress to insulate FTC commissioners from presidential removal, even though these officers indisputably wield executive powers. The executive powers of the FTC include the authority to issue cease and desist orders, as well as the other law enforcement prerogatives described in the Solicitor General's brief. They're referring here to Solicitor General John Sauer, who is the attorney who argues on behalf of the administration in the Supreme Court. We just read one of John Sauer's briefs just the other day, yesterday, I think. Humphrey's executor tried to get around Myers by insisting that none of the FTC powers were quote-unquote executive. But that assertion was false in 1935, and it remains false today. Even the D.C. Circuit panel opinion acknowledges that the FTC exercises substantial executive power, and it characterizes Humphrey's executor as an exception to the general rule that the president enjoys unrestricted removal power over executive officers. Ms. Slaughter, Rebecca Slaughter, fired by Trump from the FTC, did not deny that the FTC wields executive power. In her brief opposing the Solicitor General's application for a stay of the order by the unelected black-robed tyrannical inferior district trial court judge putting her back in office against Trump's will, and neither did Justice Elena, no, I've never been married, never had kids, why do you ask, Kagan, in her opinion dissenting from the stay that this Supreme Court did issue. So right now, Slaughter's not in her job. A federal judge ordered Trump to put her back in the job. Trump asked the Court of Appeals for a stay. They said no. Trump appealed to the Supreme Court. They said yes. So they froze the order putting her back in office. The Supreme Court did. So right now, Rebecca Slaughter is not on the FTC issuing orders. Back to the brief. So Humphrey's executor's attempt to distinguish Myers by denying the FTC holds executive powers was transparently bogus, and not even Ms. Slaughter appears willing to defend Humphrey's executor on that ground. So the Supreme Court must choose whether to follow the holding of Myers or the holding of Humphrey's executor. If the Constitution gives the president an at-will removal prerogative over those who wield executive powers, as Myers holds, then the president has no less authority to remove an FTC commissioner than he had to remove the postmaster in Myers, who merely oversaw a local post office and had nothing approaching the present-day executive powers of the FTC. But if the Constitution allows Congress to limit the president's removal powers over the FTC, then the Supreme Court, cannot simultaneously insist that the president enjoys a constitutional right to remove a mere postmaster who holds far less executive power than an FTC commissioner. The constitutional jurisprudence of this Supreme Court must be based on principled and reasoned distinctions. It is not only nonsensical, but backward for this Supreme Court to continue insisting that Article 2's vesting clause empowers the president to remove a postmaster, but not an FTC commissioner who wields far more extensive executive power. Worse, the decision in Humphrey's executor was made possible only by pretending that the FTC had no executive powers, even though the FTC had been empowered to bring enforcement actions against alleged wrongdoers even in 1935, the year of Humphrey's executor. Rulings and opinions of this sort bring the Supreme Court into disrepute. They're appealing now to Chief Justice John Roberts' inclination to rule in defense of the stature of the Supreme Court. Rulings and opinions of this sort bring the Supreme Court into disrepute, as no one seriously believes that the FTC lacks executive power, especially today. This Supreme Court should acknowledge the obvious and hold that FTC commissioners wield executive powers and that they therefore fall under the rule of at-will presidential removal established in Myers. The court should disavow Humphrey's executor's attempt to establish categories of quasi-legislative and quasi-judicial powers, neither of which have any legitimate existence in our constitutional order. Humphrey's executor should be overruled for an additional reason: its attempt to recognize categories of so-called quasi-legislative and quasi-judicial powers is incompatible with the separation of powers established by the constitutional text. Under the Constitution, there are three, and only three, categories of power wielded by the federal government: legislative, executive, and judicial. Article 1, Article 2, Article 3. The legislative powers are enumerated in Article 1 are vested entirely in Congress. The executive power by Article 1. The executive power is vested entirely in the president by Article 2. And the judicial powers of the United States is vested entirely in the Supreme Court and the Article 3 courts established by Congress, as set out in Article 3 of the U.S. Constitution. The notion of a federal agency exercising quasi-legislative or quasi-judicial powers is foreign to the Constitution, as the Supreme Court recognized only 5 years ago in a case called Selah Law. Humphrey's executor also fails to define the scope of these quasi-legislative and quasi-judicial powers that would allow Congress to insulate officers from at-will presidential removal. Does agency rulemaking qualify as quasi-legislative, or is it purely executive? Is any type of agency adjudication an exercise of quasi-judicial power? Under the Administrative Procedure Act, which did not exist at the time of Humphrey's executor, all agency action is now classified as either rulemaking or adjudication. So does Humphrey's executor mean that every agency official can now be shielded from at-will presidential removal on the ground that each of his actions must be categorized as either rulemaking, quasi-legislative, or adjudication, quasi-judicial? No one seems to know the answer to these questions, and this Supreme Court has never attempted to define the contours of these so-called quasi-legislative and quasi-judicial categories. Instead, this Supreme Court has cabined or limited the scope of Humphrey's executor by claiming that it allows Congress to establish so-called independent agencies only when they are, quote, led by a group of principal officers rather than a single individual. But there is nothing in the Constitution that even remotely suggests that the president's removal power depends on whether an agency or department is led by a single person rather than a multi-member body. And nothing in Humphrey's executor indicates that its holding or analysis was affected in any way by the FTC's status as a multi-member commission as opposed to an agency headed by a single individual. More importantly, as Justice Elena, never been married, never have kids, Kagan, convincingly explained in Seal of Law, there is no basis in reason or logic for the president's removal power to depend on whether an agency is led by a single person or a multi-person committee. The distinction is entirely contrived, and it serves no purpose other than to provide a way for Seal of Law to disapprove the for-cause removal protections of the Consumer Financial Protection Bureau, the creation, by the way, of Elizabeth, not a Native American Indian, Warren, now a senator, without overruling Humphrey's executor at the time. But Seal of Law's attempt to distinguish single person from multi-headed agency leadership is as vacuous as Humphrey's executor's effort to distinguish purely executive power from quasi-legislative and quasi-judicial acts. The president's removal power should depend on whether an agency official exercises executive power or is part of the executive branch. And there is no question that the FTC commissioners satisfy this test. They exercise executive authority. Conclusion, the judgment of the Court of Appeals should be reversed. The Court of Appeals had put Rebecca Slaughter back in office. The Supreme Court has paused that order, but they need to make a final decision on the merits. And of course, America First Legal Foundation, Stephen Miller's organization, is arguing correctly on the law, as is my position as well, that the president's authority to remove executive branch personnel must be unlimited and unconstrained by Congress or the courts. No one in our constitutional order can direct the president to delegate his Article 2 executive branch authority against his will. The checks here on the president are political checks. The body politic can decline to reelect him. Congress could, in theory, impeach him, but they cannot compel the delegation of executive authority against the president's will.